Hi, my name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case In Re Disney. This case was heard in the Supreme Court of Delaware in the year 2006. Let's go ahead and jump into the facts of the case. So this is a shareholder derivative suit. What that means is it is the shareholders of the company, one shareholder or many, bringing a lawsuit in the name of the company against the company for something that the board or an executive in the company did wrong. All right, so that's the basis of this case. It is a shareholders derivative suit. The company at issue here is obviously Walt Disney. Walt Disney Company, we all know, and some of us love, some of us don't love, but it is a media giant, right? And in the early 2000s, Disney kind of had a problem. They had this longtime president, CEO, that died in a helicopter crash. And so Disney's like, we need to find a new powerhouse CEO. This is pre-Bob Iger. And they're trying to figure out who can we use. Well, there's this guy named Michael Ovitz. Michael Ovitz is kind of a stud. He's kind of a star in Hollywood as far as like a talent guy. He knows how to get talent in Hollywood. He knows how to find the famous actors and actresses and get them in contracts and get them on movies. And so they're thinking, well, Michael Ovitz would be a great fit. So Michael Eisner, basically the acting president of the company, says, all right, I know this guy Michael Ovitz, let's go ahead and start negotiating with him. And so Eisner and Ovitz go back and forth. They go back and forth with basically the heads of Disney's executive compensation committee in devising some type of compensation plan to try and lure Ovitz to Disney. Well, it's pretty lucrative, this plan. Tens of millions of dollars a year, tons of stock options, which if you don't know what stock options are, they basically give you a right to purchase a company's stock in the future. And so if the stock price of the company goes up, if you have a stock option and you bought it in 5 years before it goes up, you can exercise that option and make a lot of money. So these options kind of incentivize CEOs to try and grow and build the business. So pretty common in these types of plans, but a very lucrative plan is kind of devised and given to Mr. Ovitz. They go back and forth, they negotiate. Disney has an executive compensation expert come on board and basically talk about, is this a reasonable plan? Everyone's kind of on board, right? The compensation committee approves it. One important part of this compensation plan is what's referred to as the non-fault termination clause, or the NFT clause. What this is that if Mr. Ovitz is terminated without cause, when you're firing an employee, basically just means they didn't do anything wrong, we just don't want them around anymore. So if you fire Mr. Ovitz without cause, well, he's going to get a ton of money. And a ton of money is right. I mean, tens of millions of dollars in cash and options that he can exercise that are probably going to be in money. That is all that goes in there. Everyone signs it. Now, it's important to realize that this was a lucrative contract, but it's not for no reason. Michael Ovitz wasn't just some guy off the street. He's a star, like I said, a stud in Hollywood. He has great connections. He knows how to basically facilitate actors on sets, and this would have been great for Disney, right? He also had ownership company in his agency company. He had ownership interest in that company, which was fairly lucrative. He had tens of millions of dollars in salary over there. And so, we talk about this as like downside protection in this plan. If you're going to lure someone like Michael Ovitz and leaving just an awesome job that he's loved for years to Disney and take a risk, well, he needs some downside protection. And so that's what this NFT is. That's kind of what it's referred to as. Well, what happens? Mr. Ovitz gets in the door. He's not really a good personality fit, is kind of the way to say it. He doesn't get along well with the other executives. They're not really rubbing shoulders right. And everyone's just kind of sick of Michael Ovitz about a year into him being there. And so they're thinking, well, what should we do? Well, they start looking around for ways to try and get rid of Michael Ovitz. And they're thinking, can we fire him for cause? Well, yeah, we want to fire him for cause, right? Because then we don't have to pay him tens of millions of dollars. So how can we try and figure out to fire him for cause? Basically, Mr. Eisner and the general counsel kind of go back and forth. Can we fire him for cause? And the general counsel's like, no, he hasn't really done anything wrong or egregious that would allow us to fire him for cause. Just not being a good personality fit doesn't allow you to fire someone for cause. So ultimately, Disney decides we got to get this guy out of here, regardless. Whether we have to pay him this NFT or not, we got to get him out of here. And so we're just going to fire him without cause. Well, it's a bad day for Disney shareholders, and it's a great day for Michael Ovitz as he walks away with tens of millions of dollars in his NFT, right? In this non-fault termination clause, which gives him a lot of money if he's terminated without cause. And so the Disney shareholders, like kind of we said earlier, kind of pissed off about this. They're like, why'd you fire this guy without cause? You should have fired him for cause. Why'd you even hire this guy in the first place? Why'd you give him this crazy NFT deal? Like, you guys screwed up and we're pissed off. We lost a ton of money. So they sued Disney. Well, the question here is, did Disney fail to exercise due care? And when I say Disney, did the board of Disney and the executives fail to exercise due care when they hired Michael Ovitz and gave him this lucrative compensation deal? And the Delaware Court of Chancery and the Delaware Supreme Court pretty emphatically say no. This was informed business judgment. They say that because, there was this compensation committee that was going back and forth with Michael Ovitz, and basically they were aware of what was in this. They all knew about the NFT. They signed it, and it was, reasonable, right? Like, Michael Ovitz is a star, and if you're going to get a star on staff at Disney, you're going to have to pay him. And so everyone was kind of on the same page about how much money, Michael Ovitz was going to need to be paid if he was going to come to Disney. So we're all aware of that. And, this was, although it seems like a ton of money to the, person on the outside looking in, if you're going to try and get people like this, it does cost a lot of money. And there is this downside protection. And, they even hired an executive compensation expert. This wasn't just like them freewheeling it. They hired this executive compensation expert, and she signed off on the deal, said everything is good. And so that is essentially the ruling is saying, this wasn't a failure to exercise due care by the Disney board when they gave him this NFT and hired Michael Ovitz, because it was informed business judgment. It might not have been perfect, they said. Everyone on the board didn't really read through the agreement like they maybe should have, but they were informed, and because they were informed, they're entitled to business judgment deference, which says, as long as it was done in good faith, we're not going to really question it. The courts aren't going to try and, use hindsight 2020 to try and see that something the board did was wrong. So that's the first holding. The second holding is essentially saying, the Disney shareholders saying, well, you should have fired him for cause, and you breached your duty of care when you fired him without cause. Well, once again, the court says there's nothing in the record to support that, Disney could have fired him without cause. And the CEO of Disney, the board is allowed to fire Michael Ovitz, this guy in the president position, if they want to, at will. That's in the bylaws of the company. And so they didn't do anything wrong. There wasn't anything in the record to support that they should have fired him for cause. And it would have been probably much worse if they would have fired him for cause if they didn't have any. And so, they reasonably relied on the attorney's recommendations. Finally, there's this conflation between good faith and due care in this case. And this is a really interesting thing to talk about. The plaintiffs tried to argue that the board acted in bad faith or not in good faith when they failed to exercise due care, when they acted grossly negligent by approving this contract and by firing him without cause. And the court just says, we are not going to accept that kind of argument, full stop. That type of argument is not persuasive to us. We're not going to conflate good faith with due care. These are two separate things in the corporate law. And so they talk about how, these good faith provisions, like acting in bad faith, liability based upon that, which is essentially a subset of the duty of loyalty. If you're going to try and sue someone for that, it needs to either be really subjective bad faith, like someone's actually trying to do harm, or it needs to be, like recklessness in the criminal law, like wanton disregard, like you really know it's bad, but you're just going to like turn away. Those types of things are bad faith. But the failure to exercise due care or even gross negligence, that's not bad faith, and you can't predicate liability on bad faith actions of the board based on a failure to exercise due care or based on gross negligence. The court probably went a little bit further than it needed to in this case when it answered that question, but it did so, it said, because it wanted to provide some guidance to the corporate law. So those are kind of the key aspects. It's also worth saying that, Disney did try and, the shareholders tried to say, Michael Ovitz breached his fiduciary duty when he negotiated this lucrative contract. The court disposes of that one pretty quickly. They're like, he wasn't in the fiduciary position when he was negotiating the contract because he wasn't even hired by Disney. So he owed no duty to you shareholders when he's negotiating his contract. That's silly. That's stupid. But anyways, that's the case. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.